SMU constitutional law professor Dale Carpenter, thank you so much for joining us. We appreciate your insight as always. Obviously, a lot to discuss with this draft opinion by the Supreme Court of the United States on Roe versus Wade and Planned Parenthood versus Casey, and the fact that it was leaked. First, your reaction that the Chief Justice, John Roberts, announced that, yes, in fact, this is an authentic draft opinion and that they are conducting an investigation into this leak.
So that was an extraordinary announcement by the Chief Justice in reaction to an extraordinary leak of confidential information from the Supreme Court that is unprecedented. And I am pretty confident that the Chief Justice will make sure that no stone is left unturned to find out who was the source of this leak.
So let's talk about this draft opinion. You read it. What exactly does it mean for people at home?
It means that if the majority is held, that probably by the end of June, the Supreme Court will declare that there is no longer a fundamental constitutional right to abortion, and that states can freely regulate that procedure if they so choose. And so people will argue about abortion in their state legislatures and maybe in Congress.
Well, that's what I was going to ask you about. So, because they were said it's really up to legislators, is that right? The representatives. Right. And yes. So, but they didn't specify whether it's states or Congress, right? So there's a lot of discussion now by Democrats to what's called codify Roe versus Wade, and I guess Planned Parenthood versus Casey, and make that into law. Is that something that if Democrats do, while they have a very slight majority, if they do that, would that stand the test of time by the Supreme Court?
It might or might not. Typically, matters of health regulation are matters for state legislatures to decide. So it's uncommon for the Congress to actually regulate nationally a health matter like this. But it has happened before that Congress stepped in and outlawed a particular form of abortion, late-term abortions. And the court, at least in that case, didn't say that that was unconstitutional. But I think if Congress passed a law either protecting abortion or prohibiting it, there would be additional constitutional challenges to that power.
And so ultimately, you think it would go back to the Supreme Court?
If there is a federal law, that would go back to the Supreme Court. More than likely, you'll see a lot of state laws that will be challenged even after this decision comes down on some ground. And those may go to the courts and may go to an appellate court or possibly the Supreme Court. But that's at that point, I think abortion rights supporters at least would have to rely on the democratic process, the legislative process.
So let me ask you, because, you know, this was a draft opinion and the Chief Justice said this was not a final opinion. And, you know, this may come out in June or early July. Why not speed it up and get it out there as soon as possible?
They could do that. The Chief Justice might say, you know, we've had this decision since early December. It's time. We've had a lot of time. But I don't think the justices want to be put in the position of appearing just to react to the pressures of time events. I think they'll probably proceed on their ordinary schedule, and that might be the end of the term in the summer. I think that they may think that we've been exposed enough and we don't want to be exposed to additional pressures, but we'll see. They could do that.
And what is going on behind the scenes, let's say when a draft like this, there's a lot of back and forth, right? So this may not be the final ruling, right?
That's right. This was a first draft of the opinion that was circulated in early February. So it's now early May. So we're talking about 3 months having passed. there may well be additional drafts that have been circulated based on reactions that people in the majority had, or there may be a dissent that's now circulating in reaction to that opinion. And those drafts will go back and forth, and sometimes the majority and the dissent will respond to each other and to what they say. So I expect this draft at least will incorporate those additional changes.
You know, it was interesting. I was reading a statement by Senator Susan Collins, Republican of Maine, who said that if Justices Gorsuch and Kavanaugh agree with this draft opinion by Justice Alito, it goes against what they said during their confirmation hearings and during meetings that she held with them privately in her office. If that's the case, are there any ramifications at all?
I don't think it's likely. The reason I say that is that I believe that the justices over the last 30 years have been very careful about saying as little as possible about Roe versus Wade. They have, no justice has promised never to overrule a decision, and no justice has promised to overrule a decision. So it's, you know, if you search the public record on these nominees over the years, they've been very careful to sort of artfully craft their answers to avoid a firm commitment.
And your thoughts just on the language used in this draft opinion as far as the conclusions. Justice Alito and the majority called Roe versus Wade, quote, egregiously wrong and deeply damaging, and basically said that Planned Parenthood versus Casey, the decision in 1992, prolonged the court's error. What do you make of that?
Well, I think that is that sort of language and rhetoric is very common for Justice Alito. He writes in very strong, clear terms, very emphatic terms that might be softened in the final product. I have no idea, but it very much fits in, I think, with the style of opinion that Justice Alito likes to write. And so I'm not surprised to see that kind of language.
Were you surprised at all about this draft ruling? And the reason I ask is because there were those who I spoke with, Senator John Cornyn included, who thought that Mississippi's law would be, you know, the 15-week ban would be the new standard of viability for abortion. So were you surprised by this draft opinion that suggests that the court is ready to overrule Roe versus Wade?
It would have depended on when you asked me. So if you had asked me before the oral argument in early December, I would have been surprised. I might have thought that the Chief Justice would be able to swing a justice over to his intermediate view. But after the oral arguments in December, I really did think that the court was ready to overrule Roe versus Wade and Casey. And by the way, it's not impossible that that could still happen, that the Chief Justice could persuade a justice to come over to his view, apparent view, we don't know for sure, his apparent view that Mississippi's law should stand, but should be allowed to should be declared constitutional, but Roe should be kept in place. But that now seems unlikely to me.
So you think on face value, this looks like a 5-4?
The reporting indicates this will be a 5-4 in terms of overruling Roe and Casey, probably a 6-3 in terms of upholding the Mississippi law. So that would include the Chief Justice, but not include him in Roe and Casey. But again, that's based solely on this reporting from Politico, and that has not been confirmed yet.
So let's talk a little bit about the leak. And today, you know, the Chief Justice announcing that there is going to be an investigation into this and who leaked it. Are they ever really going to find out who did this? I mean, there have been leaks from the Supreme Court before, perhaps not a draft opinion such as this. So do you anticipate that they're going to get to the bottom of this?
Well, there are only a few dozen people who would have had access to that opinion at most. And so it's not that hard from that world of people to find out who might have been involved, and if they used, email or something like that. Obviously, I think all of those kinds of sources will be checked. It could be that a reporter would be asked to reveal that source, and of course the reporter could refuse, but then might face their own legal consequences. So I think that the Chief Justice is going to leave no stone unturned, as I said. This person is whoever leaked this draft opinion committed a really extraordinary breach of confidentiality in the Supreme Court. This kind of leaking occurs all the time in the executive branch, in the White House, and of course in Congress. Nothing like this has ever occurred in the Supreme Court. This person, whoever it was, I think is the sort of deep throat of the modern era. The person who revealed that President Nixon was involved in the Watergate controversy back in the early 1970s to the reporters from the Washington Post. This is going to be a person that's very focused on, and if we find out who it was, it's a potentially career-ending fact.
What about criminal charges?
That I'm less sure about, because I don't know what the specific criminal charges might be, but that's something you could certainly be concerned about, because these people take an oath of confidentiality to the court system.
I was going to say, they're warned, aren't they, when they sign up for this job? They can't do this.
You cannot reveal the court's internal deliberations, much less a draft opinion. Extraordinary, extraordinary.
And what is the motivation to leak this?
Well, I'm not sure. It could be any number of people who might have had the motivation. You could have someone who opposed the decision, who wanted to sort of reveal it, expose it to the public so that there could be an early reaction and maybe some justice would switch their vote. It could have been from someone who supported the decision and actually was concerned that one of the justices might dissent or might actually go to the other side and wanted to keep them on the majority side. It's just speculation at this point. We have no idea who it is or what the motive might have been. But what we do know is that nothing like this has ever happened.
And what is the impact on the operation of the Supreme Court, do you think?
Well, I would think that in addition to conducting an investigation and determining who it is and making sure that person is appropriately disciplined for this action, if it's more than one, then more than one. But I would think the court is going to institute some additional safeguards and maybe even tighten more the people who have access to these opinions in their draft form. We live in a different era. We live in an era when information wants to be free and can be free to billions of people in a few seconds.
But how important is the process where you have these justices, basically negotiating behind the scenes on these opinions? And why is that so important to have that process that's kept out of public view? And do you think that this really hurts the trust factor between the justices themselves?
Potentially it hurts the trust factor. Again, it depends on who the source of the leak was. If it was a justice, that would be beyond extraordinary. My guess is it wasn't a justice, but I think that will be a concern. And I do think it's important that the justices be able to exchange views in some kind of internal private manner, because they don't want to feel pressured by the public to adopt a certain position or be dug into a certain position just because early on they had a certain view about the case. They may have second thoughts, and they should be allowed to have the time to have those second thoughts and have a discussion before they actually commit themselves publicly. That's important. It's important not just to the outcome, by the way. So the outcome may be foreordained, but the way in which the opinion is reasoned and the things that it says may have impacts down the road that all of the justices and all of us should be concerned about.
And, as far as this is concerned, my question is, because Justice Alito said at various points that they, as justices, cannot be concerned about, what people think, what lawmakers think. That's their world, not, the justices' world and the court's world and what their role in society is. How worried are you about that taking a hit on such a thing?
Yeah, so the justices do not like the public to apply direct pressure, or they certainly don't like to appear to be caving into any kind of outside pressure. They want to appear to be principled and neutral in their decision making, simply applying the law. And so they don't want to ever appear to be simply bending to pressure. And the problem with leaks like this, and the court thought the problem with a decision like Casey, is that it can appear that the court is actually kind of bending to opinion. And that's something they desperately want to avoid, I think. The law has to have a kind of a majesty and independence. It's one of the reasons, for example, that the justices don't like cameras in the courtroom. They really don't want people to see what's happening right in the courtroom, because they don't want lawyers and justices, other justices, appealing to cameras and to public relations. This is a public relations disaster for the Supreme Court.
And I wanted to ask you one other question, and that was just about other cases that were mentioned in this draft opinion. Obergefell versus Hodges, which legalized same-sex marriage, and also Lawrence versus Texas, which outlawed laws against homosexual gay sex. And so I'm wondering, how worried should people be about some of these other opinions that the court has issued prior to this? At the same time, I also mentioned that Justice Alito said this draft opinion was focused solely on Roe versus Wade and Planned Parenthood versus Casey.
That's right. So I think it was a large step. It is a large step if the Supreme Court is actually going to overrule the abortion precedent. It's a large enough step to overrule those. To bite off even more decisions and call them into question would really be stretching things beyond a point where I think most justices would be willing to indicate. I don't think that the opinion calls into question directly and immediately other kinds of rights, like the right to same-sex marriage, and by the way, the right to use contraceptives, and the right to interracial marriage, and other sorts of rights that aren't listed in the Constitution. And I think the court went out of its way to say that those other rights are different in the sense that they don't involve fetal life or unborn children, which is what Mississippi law termed it. And that interest of the state in protecting fetal life is of a much greater extent and degree than is the interest in, say, keeping interracial couples from marrying, or even keeping same-sex couples from marrying. So I think the court was pretty careful to say, this is limited to this decision. It's a ticket good for this right only, in a sense. And we don't want to call into question those other decisions. But if I can just add this, that doesn't mean that ultimately down the road somewhere, these other decisions might be brought into question, because the mode of analysis that the court used in this opinion, or is using in this draft opinion, is a mode of analysis that is not very friendly to unenumerated rights, those not listed specifically in the text of the Constitution, or those not found in the history and traditions of the country. So I think directly and immediately, no direct threat. But down the road, I think supporters of those other rights need to be on watch.
You brought up a good point, and that was about, and Justice Alito had mentioned this, that yes, this is not, a right to an abortion is not mentioned in the Constitution, and it's not part of the foundation of the founding of the country. How important is that? Is that not the backbone of the Constitution?
Yeah, so I would say that way of thinking about constitutional law is a very mainstream conservative legal movement view of the Constitution, that rights that can't be traced directly to the text of the Constitution or found somewhere very deep in the specific traditions and history of the country are not protected, and they are up for grabs. That, I think, is very much within the mainstream of conservative legal thought. On the other hand, the court has decided a whole lot of cases in which the rights can't be directly traced, at least not easily, to one of those two sources. So that's why I say that the way in which the court goes about its decision-making in this case, in the draft opinion, is something to be watched in the future for these other rights.
And how, because a lot of people want to know, how can a court take away a right that was granted, 50 years ago, almost 50 years ago? How can they take that away suddenly? A federal right, a right that's good in all 50 states.
Well, they can take it away because they're the Supreme Court. And the Supreme Court is the body that is ultimately the interpreter of our Constitution. And if it thinks that it made an error, in particular, if the court thinks that it made an egregious error, it can decide to reverse an earlier decision. And the key, I think, to this decision was that the court found that Roe and Casey were not only wrong, they were egregiously wrong. They were very poorly reasoned. They didn't have much historical basis whatsoever and just were very thin. And so our system says that cases like that have to be left to the legislatures and not to the courts. So that was a significant finding by the Supreme Court. It has overruled decisions in the past. In fact, the court listed about a page and a half or 2 pages in a footnote of decisions, important decisions that had been overruled over time. And that's to show that the court can change its mind from time to time. It does happen, and now it appears like it's going to happen again.
SMU constitutional law professor Dale Carpenter, thank you so much for your time and for your insight on this issue that everyone is talking about.
My pleasure.